Morning.
Good morning, Mr. Bonner. Thank you for joining us. My name is Amanda Carl. We have met before.
Yes, we have.
I'm the vice chair of the 50CA JNC. Thank you for coming out to lovely Oviedo this morning to join us.
Always a pleasure.
You know how the format works. You've been here before, but we'll go around and introduce ourselves, tell you where we're from, and then we'll give you a couple minutes to do any opening remarks that you'd like. Then we'll ask some questions, and we'll leave a little time at the end if you wish to make any final remarks. Just so you know, as you've noticed, Volusia Exposed will be recording interviews today, and some of those might be up on their website. So I just wanted to make you aware that the filming is happening this morning. And
I'll behave myself.
Craig, we'll start with you.
Craig Dyer, Public Defender's Office in 7th Circuit.
Good morning, Tetra Brownlee with the Brownlee Law Firm.
Good morning, Brett Renton, Swensonville in Orlando, Florida.
Andy Bardos with Great Rocks.
Vid Citro, law offices, 408 in Citro.
David DeArmas, Kramer Price, and DeArmas in Orlando.
Go ahead.
Well, as you know, I'm Bob Bonner. I've been a trial lawyer for 37 years. During that time, I've tried over 80 cases. I've handled over 100 appeals, both in state court and federal court. I've been blessed to have a good career as a trial lawyer. I had opportunities my parents did not have. And at some point, you get to the stage in your life where you want to pay it forward. I don't think you can pay it back because the people who helped you along the way are long gone by now. But to pay it forward is something we can all do. So one way we can do that is through public service. And a part of public service that I believe that my skills would be appropriate for would be serving as a member of the judiciary. Certainly, I have outstanding experience at the trial level and the appellate level. I've written more briefs than I can count and had oral arguments before the 1st DCA, the 5th DCA, the 2nd DCA, and the 11th Circuit Court of Appeals. So I believe that in order to help me pay it forward, a position on the judiciary would be the place to do it.
Thank you. I had the pleasure of vetting you this time, so I'll go ahead and start with questioning. I know we've talked before, so we've asked you a lot of questions before. I have a couple questions to start off.
Sure.
One, is there a case that you have read recently that is particularly well-reasoned, and why?
I read the 5th DCA opinions that came out last week. The one that caught my attention was McGregor versus Daytona International Speedway. That was a case where I believe it was Judge Higbee granted summary judgment in favor of the Speedway. In that particular case, the plaintiff was injured while in the infield during an SCCA event. She had signed a release and waiver under 549.01. The court granted summary judgment based on that release and waiver, but it was reversed because the allegations were that there was gross negligence on the part of the Speedway. In reversing, they said that not only did the statute specifically exclude gross negligence as conduct that could be released under a 549.01 release, but also that the court erred in also finding that the conduct alleged did not rise to the level of gross negligence because that was an issue of fact for a jury to determine and not an issue for the court to determine. I would blame the lawyer who represented the Speedway as much as the judge for that, because I don't know how a lawyer in good conscience, recognizing his ethical obligations, could argue a statute where it specifically has in the definition, this does not apply to gross negligence. But the court caught on to both the issue of the statutory definition and the issue of fact and reversed it. I thought that was a good decision by the 5th District Court of Appeal.
Okay, thank you. One more question, and then the rest of the panel will ask some questions. I know you spent a lot of your career in offices and law firms and with a lot of people. How do you think that you would adjust if you were on the 5th? Sometimes it can be a lonely place. sometimes you're kind of on your own. Do you think that you would be able to adjust to that type of environment?
Well, unlike a lot of people, I don't work at a big law firm. I had started with a firm that had around 20, 25 lawyers. I'm in a firm now that has 7 attorneys. I work on my own practice there. I do not have an associate. I have a paralegal, and that's it. So when I'm doing my work there, when I have a conflict, I can get one of my partners or associates to follow it, but I do a lot on my own. So being on the bench, as I understand it, you have law clerks, you have assistants, you have colleagues there. It's actually probably more people than I'm used to working at the present time.
Thank you.
I'll ask you a question. Mr.
Sure.
Bonner. Thanks for being here.
Thank you.
In the case that you just alluded to, say that the 5th District Court of Appeal had, say, gotten it wrong and misinterpreted the statute as the trial court did. Say you were appointed and you were on a panel and you had a case that was quite similar to that case, and you knew that the binding precedent out of the 5th District said this misinterpretation of the statute is what's going to ride, right? They've misinterpreted it and you're now bound by that decision. Say you even have a judge on your panel who authored that opinion where they got it wrong, okay? So how do you handle the balance between that issue with stare decisis and the fact that you think it's completely wrong based on the statute, and the aspect of collegiality? You know, you have to deal with this judge who authored that incorrect opinion. What would you do in a circumstance like that?
Well, to start with, I think the 5th DCA can change their own decisions. It's not like it's the decision from the Florida Supreme Court. So to that extent, you could look at the facts of the case, you could look at the law, you could discuss it among your colleagues in a manner that's not going to ruffle feathers. And if the judge who wrote that opinion and the other judge on the panel decide to stick with it, you write a dissent, you write it in a way that's not rude or condescending, but explaining why you think they got it wrong.
So if they were inclined to PCA, you would author a dissent?
Yes.
Thank you.
Good morning, Reverend. I've just got a question regarding, do you believe that we should require the names and nominees that we send up to have judicial experience? I believe that's extremely important.
I do not. If you look at the history of the 5th District Court of Appeal, there are a number of judges who've served on that court who did not previously serve as a trial court judge. Bill Palmer, who's recently retired, Judge Eisnagel, who's still on the bench, Judge Sharp, Judge Ployce. Those are the ones that come to mind immediately. If you look at the Florida Supreme Court, there are justices who've served on that court who did not have trial court experience or any experience. If you look at Justice Charles Wells, who was here from Central Florida, he did not have any trial court experience before he was appointed to the Florida Supreme Court. The most important quality would be the ability to look at an issue, to look at the law, and to apply the law to the facts as they are in the case.
Sure. And what do you think is the biggest current, or the largest current challenge to courts being able to maintain their integrity and independence?
Well, politics often tends to get in the way. If you look at Federalist 78, it's clear that the court system is supposed to be independent of politics and is there for the purpose of judicial review. And if there is some act of the legislature that is contrary to the Constitution, that's when they exercise their rights to strike down that act of legislation. But that's a power that should be exercised with restraint by the courts, and only when it is clear that the act of the legislature violates the Constitution.
You touched on constitutional questions. I'm curious how, and this is something that has come up a number of times over recent years, citizen initiatives are added to the Constitution and then courts have to interpret those. So in constitutional interpretation, particularly if you're looking at a recently adopted citizen initiative, how would you go about interpreting? What method do you follow? What sources do you look to in interpreting the meaning of the constitutional provision?
Well, I'm a textualist and an originalist. I don't believe you can look at some sort of past writings that went into the adoption or the writing of the citizen initiative. You have to look at the plain meaning of the words that is in that amendment and take the plain meaning of those words in order to interpret it.
Mr. Bonner, I noticed in your application that you have applied starting in 2015 for a number of judicial offices, predominantly trial courts, specifically U.S. District Court judges in the northern, middle, and southern district of Florida, and then twice for magistrate judges in various districts within the state. And given your background, which a lot of trial experience and voted members, some very impressive things, why now do you wish to go for an appellate court position, which is obviously very different than that of a trial court judge?
There is no doubt that the job of an appellate judge is different than the job of a trial judge. A trial judge has responsibility for the case from its inception to its conclusion. The trial judge has to make a great number of rulings at the spur of the moment. When you're in trial, you have to make rulings on evidence as they come before you. You don't have the luxury of extensive research. You have to make that ruling based upon your knowledge as the issue comes before you. The job of an appellate judge is different. It is an intellectually challenging job, but it involves looking at the issues that come before you on an established record from the trial court, doing research on those issues and coming to the correct result, having looked at the record, the issues, and the law as it is before you. I have experience, as I've indicated, both as a trial lawyer and as an appellate lawyer, and I believe that I would be well qualified as an appellate judge because of that experience.
Heard the phrase on PCAs from DCAs. What are your views on the procurement firm process and how they've been used in, say, the last 10 years?
As I indicated the last time I was before this group, as a litigant, I'm not a fan of PCAs because I would like to know why I won or why I lost. More if I lost than if I won. But I understand that PCAs are necessary when you've got a situation where the law is clear, there is a limited amount of judicial resources, and if you're going to be spending your time writing opinions on things where the law as applied to those particular facts is clear, it's been beaten to death, then PCAs are unnecessary.
Do you think they are being used properly or improperly currently overall?
The ones I've experienced all appear to be properly used. I don't think I've ever got a PCA where the law was not clear, either as the appellant or as the appellee.
Any questions? You have a couple minutes if you'd like to make some closing remarks and tell us anything else that you'd like for us to know.
Well, as a trial lawyer, as an appellate lawyer, my job has been to serve the interests of my client and to advance those interests before the court. Those interests do not always coincide with the interest of justice as much as we'd like to believe so. As a judge, it would be my job 100% of the time to do the right thing and to advance the interest of justice. I believe that my experience as a trial lawyer and as an appellate lawyer makes me qualified to do that, and I would respectfully request that you submit my name to Governor Scott for appointment to the court. Thank you.
Thank you so much, Mr.
Thank you
Bonner.
for coming.
Thank you for
Thank
coming.
you.
Happy holidays.
Happy holidays to you too.